Michael Jordan, Paul McCartney, Alec Baldwin, Michael Strahan. If you're a divorce attorney, is this the case you want?
This is the American Law Journal, made possible in part by King, Spry, Herman, Freund, and Fall, serving its clients in family law, business, personal injury, and school law matters for over 30 years. Cozen O'Connor, a full-service, client-oriented law firm among the 100 largest in the United States. Einhorn, Harris, Asher, Barbarito, Frost, and Ironson, one of the largest family law practices in the state of New Jersey. And the Legal Intelligencer, the nation's oldest daily newspaper for lawyers.
Michael Strahan is one of the best defensive players in New York Giants football history, but his divorce is a mudslinging mess. Gene Strahan's lawyer joins us tonight. Alec Baldwin's rant at his child made all of the gossip columns, but what are the legal implications? Good evening. Oh yes, we know all the sordid details, but what can lawyers and lay people learn from big-time celebrity divorce? Four guests give their legal opinion this evening, including one who is right in the middle of the Strahan litigation. Don Spry joins us once again from the Eastern Pennsylvania firm of King, Spry, Herman, Freund, and Fall. Don has represented professionals, business owners, and community leaders in complex matrimonial matters now for over 30 years. Bonnie Frost is a partner with the renowned family law practice of Einhorn Harris in Denville, New Jersey. Bonnie is the incoming chair of the New Jersey State Bar Association's Family Law Executive Committee. David LaDove is a partner at Cozen O'Connor and the current chair of the Family Law section of the Pennsylvania Bar Association. And Ellen Marshall is a solo New Jersey family law practitioner. She represents Gene Strahan, who is divorcing football star Michael Strahan of the New York Giants. Folks, we're not taking your telephone calls tonight, but we want to remind you, if you need more information, it's real simple. Go to our website, lawjournaltv.com, AmericanLawJournalTV.com, where every program that we broadcast here later goes up to our website as a webcast. If you need the name of an attorney in about 3 dozen different areas of practice, want to simply find out what's coming up next, go to the website, call us toll free, 888-78-LAW-TV. Write to us at info@lawjournaltv.com. Go to the website, get your law on demand. Ellen, let me start off with you. This case really has it all, doesn't it? I mean, there are allegations of adultery and forgery and lying and perversion, which again keeps the gossip columnists in business, but it's also got a lot of great lessons for lawyers, dealing with prenups and trying cases in the press, mediation, etc. In some ways, is this kind of a once-in-a-lifetime kind of case?
It probably will be a once-in-a-lifetime kind of case for me, but other than lessons being writ larger, it's not very different from the dynamics in many other kinds of cases.
Do you find, Ellen, though, well, first off, let me ask you, how did this case find its way to your door?
It was referred by a former client.
Okay. And you know when you're going to handle a case where you're dealing with a celebrity, facts, details are going to get out to the press. This is not a criminal case sometimes where lawyers like to have, you know, the press pick up on their case and they really try to impact the jury pool so that they get a better shake for their client. We're talking about a family law matter. A judge or a magistrate is going to hear this case. These cases are not supposed to be tried in the press, are they?
No, they're not. I don't think any case should be tried in the press, but no, certainly not a family law case. Gene's desire was always to keep this case private, to have nothing be tried in the media, nothing brought to the media, and she was disappointed that there was so much scrutiny from the media, a lot of inaccuracy in the media, and it certainly wasn't something that we thought was helpful or wanted in any way to be involved.
Dave, have you ever been involved in a case where, again, lurid details get out into the press and it could impact either a judge's decision, or it might even affect the dollars when the case finally gets settled?
Yeah, we've had situations where, as you say, the lurid details get out in the case. And the problem that we have is that all too often in those situations, the husband, who might be a really successful business person, you start to wonder what the impact is on his business. And, you know, so often these small businesses are goodwill kinds of situations. And some of these details that get out in the press are not goodwill issues. You know, they don't help someone's goodwill. They just do the opposite. And as Ellen was saying earlier, it's sometimes harmful. It has the opposite effect. It doesn't help at all.
Oh, of course, but Bonnie is talking about the impact on someone's business, on someone's reputation. But let's talk about, first and foremost, the decision made in this case, and maybe again the dollar figure in an equitable distribution or alimony scenario. Is that going to impact that at all? It really shouldn't, right?
It shouldn't, but I think the sheer numbers are sexy, and it's very difficult when you have a judge on a bench, and at least in New Jersey they make $140,000 or thereabouts, and it's very difficult for them to understand, I think, because they're human beings, $15 million, $25 million, even though intellectually it's just a case with another 0 or 2 at the end. The reality is that it's difficult for judges, I believe, to understand lifestyle, understand how much someone's budget really is, how much it really costs to run their household when they're living on $140,000 a year. Not that it has anything to do with this judge, but I think it's a matter of human nature, and I think it does affect it.
So in a roundabout way,
subtle way.
Okay, in a roundabout way, it could be a leveraging device. I'm not saying that Ellen did that, intentionally or unintentionally, but I'm saying that people who do represent big-time players, if you will, could gain an advantage by taking it to the press.
Let me come in here for a second,
Go ahead,
Chris,
Dave.
if I may. Some of the situations that we have, it's a double-edged sword, because as Bonnie was saying, you know, here's a judge who makes $160,000, and you know, the case in front of him, the guy makes $5 million a year or $8 million a year. On the other hand, they also sometimes lose track of those numbers. They become fairy numbers. It's just some myth. So what does it matter if the judge is ordering the payor, the husband in this particular situation, to pay $500,000 a year because he has $8 more million to go? So again, it's a double-edged sword. I agree with Bonnie's analysis that it's very hard sometimes for judges who are on a fixed income, and if they have spouses who are on fixed incomes, to even conceive of these lifestyles. Before I drove up here today, was dealing with a case where the numbers were significant. And it's a lifestyle issue that our courts just aren't used to.
But in a case like Strahan, it's an easier lifestyle number to prove because they had such a conspicuous lifestyle.
Yeah.
Private jets, limousine service, an enormous house, being invited to all the finest openings and all the finest parties in New York Magazine. We weren't inventing anything ever. I don't think any of us do, but in this instance, there was so much that had been reported in magazines over the course of the Strahan's marriage, television shows on the house remodel and so on, that we had a huge video library of what the Strahan lifestyle was absolutely like, and all of the tens of thousands of dollars of free things that Michael Strahan gets by being Michael Strahan. They were very generous philanthropically. They were very well liked in the community. Their life was always very conspicuous in terms of being covered by the press. I don't think either one of them were daunted by the idea that this would be a public case. I just think that at least my client, and probably Mr. Strahan as well, would rather have had this be much more private a matter than it wound up being.
All right, so are you saying then, Ellen, that these kind of details, and again, the lurid details, secretly videotaping Jean's sister, Michael Strahan allegedly jetting off to the Caribbean with various other women, if Michael Strahan takes this to mediation, or he and his wife can work it out, aren't some of these details going to stay private? Don't they come out into the press because the fight starts?
Well, not the fight, but the litigation. If they had settled their case, certainly a number of things that came out in the courtroom would not have come out in the courtroom. They would have remained between Michael and Jean.
So didn't Mr. Strahan and people like Strahan, again, the big personality, Don, don't they have a vested interest? Don't they have, a greater interest in getting this thing settled and settled early? Otherwise, all of this stuff is going to get out into the public.
Well, I think there is an incentive, but I think the other thing to remember is once the genie's out of the bottle, once it's out in the press, I think a lot of the negotiating power is gone. I think that one of the things that I find that those payors, if they're concerned about it, it's that the information will get out, and that may bring them to the negotiating table. But in some respects, I mean, if the person who wants to leak this information is going to be making, just unreasonable demands, I don't think that somebody's just going to cave into that normally. Now, I think politicians are the ones that worry about it the most, in my experience.
Chris, if I may, I hear what you're trying to get at, and what my experience has been, I'm going to call it the next level people. The Strahans and those ilk are used to being in public. It's the doctors in the hospitals, it's the small businessmen who are extremely successful, but they're the ones who are much more careful about their
But Michael
veneer.
Strahan also did a lot of charity work, and he's out in the public, and he represents the Giants, he represents himself, his own organization. So now, some of these details of, again, forgery and perversion, et cetera, get out there. I mean, it doesn't undermine him, ostensibly, as a defensive end, sacking Donovan McNabb, but it may impact the work that he does outside of football.
And Ellen will tell you, it might, but they're so used to the press and what they have to, excuse the expression, run blocking for the press because they're so used to it. Whereas it's this other group of people who have never been in the press and never want to be in the press. It's the doctor up the street. It's the person who has the store, the retail establishment on the corner. These are the people that I see, they don't want any of the details known.
Gotcha.
And they're the ones, and Don made a great suggestion, the politician. Those are the people who really are much more concerned about their image, about what gets out and what doesn't get out. I don't think Alec Baldwin cared what got out. He certainly didn't like what got out, but he loved going on The View to to do the counterattack against his situation.
You could say that was a Hugh Grant. He had to get out there afterwards. We'll talk about that a little bit later in the program. Ellen, was this case ever mediated? Did you folks ever try to mediate this case?
This case was never mediated.
All right, why not?
There was a premarital agreement, and both parties took the position that the premarital agreement was enforceable and controlled by Pennsylvania law. It was only partway through the case that Mr. Strahan said, oh, but only as orally modified. Oh, but only as modified by conduct. So our perception was that their position was something of a moving target. We believed the premarital agreement was enforceable and that she was entitled to the protection of that agreement, which fortunately Dave was so helpful in making clear to the court. And there was very little to mediate. In fact, we all felt the agreement was enforceable, but the difference in the interpretation was so vast that there really wasn't much we could do but ask that it be enforced.
I think that's what happens when you have mediation. Really only works when you have 15 issues to talk about. It doesn't work when you have one and you have two polar sides. So when you talk about, well, couldn't they have mediated, from my understanding, from what Ellen has said, there weren't the 15 issues that you could throw back in the pot and horse trade with. So I think that's why it didn't dispose itself to being mediated.
That was an interesting issue in the Strahan case, because we had talked about this before. Am I right that the prenuptial agreement was entered into in Pennsylvania and had a clause in it that provided that no matter where the Strahans lived, Pennsylvania law had to be applied?
You are right.
And as I recall, Dave was the expert on Pennsylvania law in the New Jersey court.
He was.
And I think that that's very common in prenuptial or postnuptial agreements, where the state that it's entered into, most attorneys will put a clause in saying that the agreement has to be interpreted under that state's law, because we don't know if it's valid under another state's law.
That's true, and certainly the Strahans had lived in Pennsylvania for years, and it was very clear that Pennsylvania law controlled, and the court was guided not only by the research of the parties' attorneys, but did its own research on Pennsylvania law, and really, we believe, applied it to the facts that occurred in New Jersey, but nonetheless that Pennsylvania law controlled.
You know, it's kind of unusual, and again, we've talked about, and we're done with the lurid details and what's on the back pages of the newspapers, but again, we've kind of picked up on this case because it's emblematic of a number of legal scenarios which are of interest to lawyers and again, to lay people. There was a prenuptial agreement here, as we've just stated, and usually when a prenuptial agreement is challenged, it's usually challenged by the lesser wage earner, often the wife, who says, you know what, I was under duress, you know, they handed this to me the night before the wedding, which I think Gene Strahan did say in this matter. But it's not Gene Strahan that really wants the prenuptial agreement overturned. It's the big breadwinner that wants to get his own prenuptial agreement overturned. If you go into court and say, well, we'd like to have our prenuptial agreement interpreted this way, Judge, aren't you already setting off on a bad foot because it was your prenuptial agreement that you gave, or your lawyers gave, to your wife?
Well, actually, Michael Strahan said at the beginning of a domestic violence trial, there's a premarital agreement, and we want to know now, today, whether Gene Strahan agrees it's enforceable. Gene Strahan was 4 months away from having given birth. Her babies were 4 months old when their marriage ended. They were twins. She had just experienced what was, in our view, clearly an act of violence. She was caught off guard. Her whole world was turning inside out, and she was asked to let the court know immediately if she believed the agreement was enforceable. And within very short order, she said, yes, I agree, it's enforceable. And as far as we were concerned, we then applied the facts to the agreement, and there we were. But Michael Strahan didn't ask that the court not enforce it. He asked that it be enforced on the terms that he liked, like an alimony waiver, like she pays her own counsel fees. But all those things he was supposed to do that he never did do, those really didn't apply because, after all, he did these other things instead. Also, in their agreement, what I think Dave and I both found interesting is that Michael was referred to as player. Gene was referred to as spouse. And here the spouse is saying the agreement's enforceable, and the player's saying, well, not exactly.
Well, that is unusual. That's my point, Ellen. Isn't it pretty unusual? Again, usually it's the person who, you know, the spouse, who goes into court and says, please upend this because they handed it to me the night before the wedding.
What Gene Strahan said, yes, I agree with you, but what Gene Strahan said is, this is what Michael and I agreed to, we negotiated it, and I'm prepared to live by it. But generally speaking, yes, it's very often the non-wage earner who comes in and says it was under duress and I didn't understand and who knew, and not me.
Another reason I think that this case is some interest. So, Ellen, where are we right now, money-wise? I know that, I think, didn't the court award Gene $15.3 million plus 20% of his yearly income for every year they were married, and another $18,000 a month were accorded to the kids for child support?
The $15.3 million included the 20% of his net income.
All right.
For every year that they were married.
I see.
And net had a complicated calculation, but she now has received about $3 million, a little more than that. She received additional monies during the case which she used, but which counts against her share. And she received her half interest in the house. The appellate division stayed the receipt